At the end of October, the Constitutional Court confirmed that retrenching employees who refuse to accept alternative employment is not automatically unfair where the employer has genuine operational requirements underlying the proposed alternative terms. Let's get more on this with Kirsten Eiser from Webber Wentzel. She's a partner there. Thanks so much for your time on SABC News this afternoon. In simple terms, what does this judgment mean?
Hi, Ntinke. Thank you for having me. In simple terms, what this matter means is that employers have greater flexibility, that when they're facing a situation where they have genuine operational requirements and they make a proposal that can involve changing terms and conditions of employment, if employees refuse that proposal, they are then able to dismiss those employees without fear of a claim of an automatically unfair dismissal.
Mm-hmm. How was the issue first raised in court?
So it goes back quite some time. How this issue first arose was actually all the way back in 2010, where there was a major decline in the steel industry. Now, the employer in this case, Avenge, is a large steel manufacturer. And stemming from that decline in the industry, it eventually culminated in May 2014 in Avenge needing to start a retrenchment process in terms of the Labour Relations Act. And it did this by starting with a consultation process with the majority union, which is NUMSA, the National Union of Metal Workers of South Africa. And during this consultation process, and having looked at its organizational structures, Avenge made a proposal for an alternative to retrenchment, which looked at changing job specifications and gradings, etc. It made this proposal to NUMSA, who then took it to their members and rejected it on the basis that it changed terms and conditions of employment. Avenge decided in the circumstances that they had to retrench employees due to their operational requirements. Now, NUMSA was of the view that the reason for the dismissal was as a result of the employee's refusal to accept a demand of mutual interest, and in terms of our law, that is an automatically unfair dismissal. Mm-hmm. So that's the background. In terms of the court process, it then went to the Labour Court, who found that the dismissal was not automatically unfair because the reason for the dismissal was the employer's genuine operational requirements. Mm-hmm. It then went to the Labour Appeal Court as NUMSA was unhappy with the Labour Court judgment. And there, the court said that in dealing with automatically unfair dismissals of this nature, there is a two-pronged question. The first being whether, but for the employee's refusal, would the employees have been dismissed? And even if that answer is no, they wouldn't have been dismissed if it wasn't for the refusal. The second part is a causation test, which asks what is the dominant or proximate cause of the dismissal. And on applying that test, the Labour Court held that the dominant and proximate cause for the dismissal was Avenge's operational requirements.
Mm-hmm. Kirsten, can you explain what this means now, the fact that the Constitutional Court has confirmed that Labour Appeal Court ruling, that there were three separate judgments in the Constitutional Court that essentially agreed with this, and what does it mean for employers and employees in a South African context going forward?
So, as I mentioned before, for employers, it means greater flexibility. They are able to effect changes without fear of, if the employees refuse those changes, of an automatically unfair dismissal. For employees, I suppose it also means that they need to be more flexible. If in a retrenchment process, an employer comes forward with a proposal that needs to be evaluated, and the employees need to know that if they refuse that proposal and there are genuine operational requirements for the dismissal, they won't have a claim for an automatically unfair dismissal. And significantly, what this means for our economy is that this judgment allows for the viability of employers. We're in a situation where our economy is in a huge decline, and this allows employers to put the measures in place to ensure they survive. And while it may mean that 100 employees lose their jobs, in the long run, it means that perhaps 300 employees can continue in gainful employment.
Mm-hmm. Kirsten Eiser from Webber Wentzel, thanks so much for your time on that, giving us some insight into some labour relations matters and what that Constitutional Court judgment from the end of October means.